Your Honor, I believe you might be muted.
Thank you for pointing that out to me. We are on the record now in the matter of Marks v. Sonny's Rooftop Bar. My name is Judge Lipsitz. I'll be presiding. Can I get announcements and appearances from counsel, starting with counsel for the plaintiff?
Yes, Your Honor. Good morning, Your Honor. My name is Madeline Levin, and today I represent Ms. Marks' estate. I'm joined by my co-counsel, Ms. Abigail Becker.
Good morning, Your Honor.
While you won't be able to see or hear Ms. Becker, she'll be assisting me with the technological components of today's trial.
Very well. Good morning, counsel. Defense?
Good morning, Your Honor. My name is Shannon Climaco, and I represent the defendant, Sonny's Rooftop Bar. I'm also joined by my co-counsel, Mr. Maitreya Gowda. Mr. Gowda is going to run the tech for today's trial and just do his best to keep me on track.
Excellent. Good morning, counsel. With that, before we bring in the jury, is there anything we need to take up pretrial?
Yes, Your Honor. The plaintiff just has a few housekeeping matters to address.
Okay.
First, we'd like to note that Exhibits 1, 22, and 23 are pre-admitted and may be used by either side at any time.
Counsel for defense, is that your understanding?
Yes, Your Honor.
Okay. The court will take notice and they will be admitted when the record opens, and you can use them in opening if you so choose. Anything further?
Yes, Your Honor. We'd also like to note that parties may not amend the pleadings at trial and that opposing counsel has raised an affirmative defense of comparative negligence.
Okay. Is that your understanding as well, defense?
Yes, Your Honor.
Noted.
And finally, Your Honor, as it relates to screen sharing, may we assume that when authenticating an exhibit, it's constructively outside the presence of the jury and that once entered, it's published?
Yeah, so what you can assume is when presenting an exhibit that has not yet been entered into evidence, you can freely screen share, just note for the record what you're doing. When that happens, the only people that see it are myself, opposing counsel, and the witness. What the jury, you can assume, sees is a blacked out screen, but still hears audio. Once I grant it into evidence, I will unblack the screen and the jury can see it as well.
Yes, Your Honor. And if you can't hear or see me at any point, please do feel free to let me know either in the chat or verbally, and I'll do my best to fix the issue.
Absolutely, and would request the same from counsel as you have already demonstrated already.
Of course, Your Honor. And with that, plaintiff is ready to proceed with opening statements.
Excellent. Defense.
Yes, Your Honor. Just a few procedural matters. First, may we assume that all objections are made outside the presence of the jury?
Yes.
And to clarify the exhibit sharing for the screen, may we have permission to freely share exhibits once they're already admitted by Your Honor?
Yes. I would just recommend when you're sharing that you note for the record what you're doing, because the transcript for this case will only record what you say, not what's on the screen. Yes,
Your Honor. And finally, I'd like to draw the court's attention to the pretrial order issued by Judge Pasquarello, specifically stipulation 14. Now, the defense has stipulated that the decedent Jessica Marks was born on January 20, 2000, which means she was a minor on the date at issue in this lawsuit. We concede that Sonny's Bar served Ms. Marks alcohol when she was a minor, which means the only thing at issue today is whether the Ms. Marks was obviously intoxicated when she was served.
Okay. Is that accurate, Ms. Levin?
That's correct. That's our understanding as well, Your Honor.
Okay, noted.
Nothing further, Your Honor.
Very well. With that, I believe we're ready to move into openings and bring in the jury. A reminder to our jurors, you may want to switch to speaker view for opening statements. And with that, I'll turn it over to counsel for the plaintiff.
Yes, Your Honor. They ignored the obvious. It's March 24th, 2019. A woman named Sunny Mehta is working a shift at her bar in Malibu. It's a slow night. Miss Mehta is doing what she normally does, taking orders, serving drinks, but she's not doing her job. She's ignoring the obvious. You see, there's a 19-year-old girl in that bar, Jessica Marks. She's been ordering drinks all night, and Miss Meta, she's been serving her. Miss Marks doesn't know it herself, but it's clear to everyone around her. She's not okay. Members of the jury, you'll learn Miss Meta could have cut Miss Marks off at any point. She chose not to. She chose to ignore the obvious. And you'll learn that when she did, Miss Marks got into a car crash and she died. Good morning. My name is Madeline Levin, and today I represent Miss Marks' estate. We're here because of California's Dram Shop Act. It's a law that says if a bar serves an obviously intoxicated customer, they're legally responsible for what happens next. That's why Miss Marks' estate is suing Sonny's Rooftop Bar for wrongful death, because they ignored the obvious when they had a responsibility to step in. So what does that mean we have to prove to you today? Well, there are three things. First, that Jessica Marks was a minor. Second, that Miss Marks was served alcohol while obviously intoxicated. And third, that contributed to her death. Members of the jury, you'll learn it's not in dispute that Jessica Marks was a minor. And you'll hear from a friend of Miss Marks, Miss Levin. She'll tell you it was clear Miss Marks was drunk that night, that she couldn't speak coherently, couldn't walk straight, and that employees at the bar themselves admitted they should have cut her off. And then you'll hear how Miss Marks died. You'll learn she had a BAC twice the legal limit, and that when she crashed, she was just 1,000 feet from the bar that had served her. Members of the jury, you'll learn Miss Meta had every opportunity to save Miss Marks' life, to do her job. She chose to ignore the obvious. And it cost Miss Marks her life. That's why, at the end of today's trial, we'll ask you to find Sonny's Rooftop Bar liable. Thank you.
Thank you, counsel. Counsel for defense, do you have an opening statement you wish to make?
Yes, Your Honor. May I proceed?
May.
May it please the court, opposing counsel, and members of this jury. Ms. Levin just told you my client ignored the obvious. That's not true, and it's misleading. This case isn't about whether my client ignored anything. It's about whether there was anything to see at all. Their evidence is going to show that my client was carefully observing Jessica Marks all evening, but that the signs of intoxication simply weren't there. There was nothing to see, so there was nothing to stop. But let's step back, because we don't disagree with everything Ms. Levin just told you. She said that Jessica Marks died in a tragic car accident 2 years ago. That's true, and it's heartbreaking. She told you that Miss Marks was only 19 years old and that my client served her alcohol on the night of her death. Those things are also true, and Sonny's Bar should not have served a minor, but when Miss Levin tells you that Sonny's Rooftop Bar is legally responsible for Jessica Marks' death, that Sonny's ignored the obvious, well, members of the jury, that's not true. That's not true for one very simple reason. There was nothing to see. So there was nothing to stop. In the state of California, bars and restaurants are allowed to serve alcohol, even to intoxicated people. The law only requires a bar to stop serving if they see that person is clearly drunk, if that customer has lost control of their faculties, if they're what the law calls obviously intoxicated. Proving obvious intoxication is going to be a problem for the plaintiff. Because you see, when my plaintiff sued my client for wrongful death, it became their burden to prove that it is more likely true than not that Jessica Marks was served alcohol while she was obviously intoxicated. The plaintiff will fail to prove that today because there was nothing for the employees at Sunny's bar to see to indicate that Jessica Marks was intoxicated. The law didn't require them to stop serving. Members of the jury, I have 3 questions for you that I want you to keep in mind during this trial. First, what did the bartenders at Sunny's actually see? You'll meet the owner of Sunny's bar today, Miss Sunny Mehta. You'll learn she visited Miss Marks's table 10 times that night, and that Miss Mehta is trained to spot the signs of obvious intoxication. In those 10 interactions, Jessica Marks didn't slur her words, she didn't have bloodshot eyes, and she didn't act in a way that would indicate she had lost control of her faculties. Miss Mehta wasn't required to stop serving. Next, can you trust the plaintiff's only witness? If they rely on only one person, you need to know if you can trust her. But the plaintiff's only witness is going to be their biggest problem. You'll learn that she was drunk that night, that she only agreed to testify after she was threatened with a lawsuit, and that her story is contradicted by multiple eyewitnesses. Finally, if you can't trust their only witness, is the plaintiff's other evidence reliable? We anticipate a video of Jessica Marks will be at the center of the plaintiff's case. The evidence will show there are reasons to believe that video doesn't reflect reality. Members of the jury, Jessica Marks's death was. That doesn't mean Sunny's bar is responsible. At the end of the trial, we'll revisit the evidence, and we'll ask you to recognize that there was nothing to see, so there was nothing to stop. Thank you.
Thank you, counsel. With that, we'll move into the evidence stage trial. I'll remind our jurors to switch into gallery view to see the attorney's witnesses on the screen. And with that, I'll turn to counsel for the plaintiff and ask if they have any witnesses they'd like to call.
Your Honor, before we call our witness, permission to read a portion of pre-admitted Exhibit 22 onto the record. It's Miss Marks's autopsy report.
Okay.
Blood drawn at the scene of accident contains 0.16 grams per 100 milliliter of blood, BAC. Ms. Becker, we can take that down. And with that, plaintiff calls Morgan Levin.
Okay. Morgan Levin, you may take the stand and you may proceed when ready.
Good morning, Miss Levin.
Good morning.
Please introduce yourself to the court.
I'm Morgan Levin.
And why are you testifying today?
My best friend, Jessica Marks, she got in a car crash on March the 24th, 2019. So I'm just here to answer questions about it.
When was the first time you met Miss Marks?
Well, we became friends junior year of high school. She was such a joy.
And when was the last time you saw Miss Marks?
That night, March 24th.
Did the two of you have any plans that evening?
We did. We planned to go to Sunny's rooftop bar.
Were you underage at the time?
Yes, ma'am. We were 19.
If you were both 19, did the bar turn you away?
No, ma'am.
Did they serve you?
Yes.
Who took your orders?
Sunny Mehta, the owner of the bar.
Let the record reflect Ms. Becker is displaying what's been pre-marked as Exhibit 14. Ms. Levin, do you recognize this?
Yes.
What is it?
It's a picture I took of Jessica and the drinks we had that night.
Does it appear to be a truthful and accurate copy of the photograph you took?
Yes.
At this time, plaintiff offers Exhibit 14 into evidence.
Any objection?
No objection, Your Honor.
Exhibit 14 is admitted without objection.
Ms. Levin, looking at the drinks on this receipt, looking at the drinks in this photograph, which ones did Miss Marks have?
She had the two White Claws, the drink with the red straw, and then the beer can.
And what time did you take this photograph?
It was around 10 p.m. that night.
Did you see Miss Marks have any drinks after that point?
Yes. She had at most another a bottle of wine, another beer, and then another White Claw, and then a shot.
Ms. Becker, we can take Exhibit 14 down now. Thank you. Ms. Levin, we talked about how much Miss Marks had to drink. Let's talk about her behavior. Did you notice it change at all throughout the night?
Yes, she began to talk really loudly. That she kind of slurred her words. She had these red eyes, and she was stumbling a little.
Let the record reflect Ms. Becker is displaying what's been pre-marked as Exhibit 10. Ms. Levin, do you recognize this?
Yes,
What is it?
it's a video I took of Jessica that night.
Did you have a chance to review this video before trial today?
Yes, I did.
And did it appear to be a truthful and accurate copy of the video you took?
Yes.
At this time, plaintiff offers Exhibit 10 into evidence.
Any objection?
No objection, Your Honor.
Okay, Exhibit 10 is admitted without objection.
Ms. Becker, could we go ahead and play that now for the members of the jury?
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy, Mom and Dad. Inspired me. Okay, well, go big or go home.
Ms. Levin, is Ms. Marks's behavior in this video consistent with how she was acting off camera?
Yes, that's how she was acting that night.
And around what time did you take this video?
I think it was later in the night, maybe 10:45, 11.
Ms. Becker, we can take Exhibit 10 down now. Ms. Levin, let's shift and talk about Sunny Mehta. You told us Miss Mehta was your server that evening. About how many times did you see her interact with Miss Marks?
She came up to our table maybe 8 or 10 times that night.
And did Miss Mehta ever say anything to you about Miss Marks's behavior?
Yeah, there was this one time Jessica and I were going down the stairs, and Jessica just completely slipped. She almost face planted, and she kind of caught herself on Sunny. And then Sunny said that we may need to cut her off.
Did Miss Mehta cut Miss Marks off after she tripped down the stairs?
No, ma'am.
Let's talk about what happened at the end of the night. At what time did the two of you leave?
I think we left at around 11:45 that night.
And when you left, did you drive home together?
No, ma'am. I got an Uber, but Jessica drove her car.
Do you know what happened when Miss Marks got into her car?
Yeah, she drove out of the parking lot and my Uber followed her, and we barely made it out of the parking lot, maybe 1,000 feet. And then she drove off the road and off the bridge, and she crashed her car.
Thank you, Ms. Levin. Thank you for your time. Nothing further, Your Honor.
Thank you, counsel. Counsel for defense, do you have any cross-examination for this witness?
Yes, Your Honor, but before I cross-examine this witness, permission to read a portion of Exhibit 26 onto the record. It's the sworn testimony of a woman named Stevie Rieger, and I intend to question Ms. Morgan Levin about Ms. Rieger's eyewitness account. Now the parties have agreed that Ms. Rieger is an unavailable declarant under Rule 804, and her sworn testimony is admissible under 804B1.
And Ms. Levin, any objection to the reading of testimony onto the record?
Not at this time, Your Honor, no.
Okay. You may proceed then.
Your Honor, I'm going to have my co-counsel, Mr. Gowda, read the answers as I read the questions.
That sounds fine.
Okay. Can you state and spell your first and last name?
Stevie Rieger, Stevie, Rieger, Reger.
We're here to talk about an incident that occurred on March 24, 2019. Where were you around 9 p.m. that night?
Sonny's, watching the end of a Lakers-Kings game. They wheel a TV onto the roof when the games are on.
Now, I'm showing you Exhibit 2. Did you see this woman that night?
Yeah, and I saw her on the news the next day, Jessica.
Were you concerned about Jessica getting behind the wheel?
She was in better shape than her friend. Her friend could barely walk in a straight line to the Uber, but I don't think anyone who drank as much as Jessica should get behind the wheel.
How was she walking?
Fine, I guess. I don't really remember. I just remember her friend was wobbling like she'd been in the ring with a boxer.
Thank you, Mr. Gowda. You can take those quotes down now. May I proceed with the rest of cross-examination, Your Honor?
You may.
Good morning, ma'am. Before you visited Sonny's bar on the night of March 24th, 2019, you spent around 3 hours with Jessica at her Airbnb, correct?
Yes,
Now, within those few hours, you each had about a glass of wine, correct?
yeah,
You're aware that Miss Marks had an Instagram account, aren't you?
yes, she did.
In fact, that video we just watched a few minutes ago, Exhibit 10, that was filmed specifically for her Instagram account, right?
Yes, she put it up.
Your Honor, permission to share Exhibit 5 on the screen for identification.
May.
Mr. Gowda. Ms. Levin, you recognize Exhibit 5 as a post from Jessica Marks's Instagram posted at 8:18 p.m. on the night in question, correct?
Yes, that sounds right.
That's a fair and accurate copy of the post as you remember it?
Yes,
The defense offers Exhibit 5.
Any objection?
Yes, Your Honor, hearsay, specifically to Morgan Levin's comment at the bottom of this exhibit, it's going to be a great night.
Okay. Response to that?
Yes, Your Honor. To the extent that Jessica Marks's comment is hearsay, it's admissible under exception party opponent. We can redact Morgan Levin's testimony if that's going to be a problem.
We would ask the opposing counsel to do that, just for Morgan Levin's statement.
Okay. So Exhibit 5 will be admitted with the statement of Morgan Levin at the bottom constructively redacted.
Yes, Your Honor. Now, we do plan to show this exhibit a few more times during the cross-examination. May we just consider it constructively redacted?
Yes, you can consider the version that's been entered into evidence as constructively redacted.
Yes, Your Honor. And it's in evidence, Your Honor.
Yes, it is admitted into evidence. I'm sorry if I didn't make that clear.
Now, ma'am, this picture shows 2 empty bottles of wine, correct?
yes, it does.
Now, let's focus on that caption at the bottom there. Jessica wrote, "The start to a good night." You see that?
She did.
So Miss Marks's Instagram depicted 2 empty wine bottles,
They did.
but I want to talk about reality. The truth is, ma'am, you and Miss Marks didn't drink those 2 bottles of wine that night, did you?
No, I think they were from earlier that week.
At best, you drank half a bottle of wine, right?
Yeah, we each had maybe a glass.
So, ma'am, Miss Marks's Instagram didn't accurately reflect the reality of how much you two drank that night, did it?
No,
Okay, let's fast forward to 11. At 11 p.m., you're at Sunny's bar, correct?
we were.
And around 11 p.m., Miss Marks pulled out her phone and handed it to you, didn't she?
She did.
She told you, like we established, that she needed you to film a video for her Instagram account, right?
Yes.
And Exhibit 10, the video we watched, that's the video she had you film.
Yes.
And that video was then posted to the same Instagram account where Jessica Marks posted the 2 empty bottles of wine you didn't drink, right?
It was posted on her Instagram. Yes.
To the same Instagram account, yes?
Yes.
Just to be clear, when you filmed that video, you didn't see any staff member from Sunny's bar near your table to see how Jessica acted for her Instagram followers, correct?
No, I'm not sure if they were around or not.
Ma'am, I want to switch gears and discuss who actually drank what on March 24th. Because one of the things you're claiming is that you didn't have very much to drink. I've got that right?
Yes, that's correct.
You claim that you weren't drunk at any point that night?
No.
Ma'am, do you know a woman named Stevie Rieger?
I briefly met her that night. Yes.
Okay. The jury heard that Miss Rieger testified you weren't even able to walk in a straight line. You deny that?
Yes, I was able to walk.
Well, Miss Rieger also said you were wobbling like you'd been in the ring with a boxer. You deny that too?
Yes, I'm not sure if she was talking about Jessica or me.
Well, you'll at least admit that Jessica, she was able to walk in a straight line when you left the bar that night, wasn't she?
She did some sort of fake intoxication test, but she fell down the stairs that night. So no, she wasn't walking straight.
Well, you said a fake intoxication test, but she was able to walk in a straight line, yes?
It wasn't perfect, but it was a lot better than I expected.
It's your testimony that she didn't walk in a straight line?
No, she kind of passed the test. It wasn't as perfect, but it was definitely better than I expected her to.
Miss Levin, she walked in a straight line, yes or no?
At that point, she did.
And Miss Marks even had the dexterity to touch her nose with her finger as you were leaving, correct?
She did.
Well, that's because the truth, Miss Levin, despite what you told this jury and despite what Miss Marks led her Instagram followers to believe, the truth is that Jessica only consumed 3 drinks at Sunny's bar, isn't it?
No, that's incorrect.
Ma'am, you remember giving a statement to the police at the scene of the car crash?
Yes.
Your Honor, we're sharing Exhibit 23 on screen. It's the LAPD police report from Ms. Marks's crash, and pre-trial has established that it's already in evidence. Ms. Levin, I want you to read the portion of the report I've highlighted silently while I read aloud. Levin acknowledged that Marks had a few drinks, and that Levin had a few also. When I asked Levin what Levin meant by a few, Levin said, "I don't know, 3." I read that correctly, didn't I?
You did.
So I want to talk about why your story has changed since you spoke to the police. You're aware that the plaintiff in this case is Jessica's mother, correct?
Yes.
After you spoke to the police, Mrs. Marks actually threatened to sue you. Isn't that true?
She did, but she's not.
Well, ma'am, you know that getting sued in a case like this could cost you a lot of money, couldn't it?
It could. I'm not sure.
Well, you certainly wouldn't want to be sued, would you?
No.
So after the plaintiff threatened to sue you, you agreed to sit down with her attorneys. Isn't that true?
I spoke with her attorneys. Yes.
You spoke with Miss Levin and her co-counsel for 3 hours the day before you were deposed in this case, didn't you?
I did. Yes. I spoke with them about my story.
And the very next day in your deposition, you changed your story and testified that it was actually Jessica who drank all the drinks, not you. And that it was Jessica who looked intoxicated, not you. That's what you testified, right?
I didn't change my story, but yes, it stayed the same. That's what she drank.
Well, you're saying you didn't change your story, but you told the cops she only had 3 drinks, right?
Yes, I was just trying to protect Jessica. I didn't want her to get in trouble.
So you did change your story that originally she had 3 drinks, but then she had more?
Yes.
So when we questioned you at your deposition about whether your 3-hour meeting with plaintiff's counsel is why your story changed, you claimed you couldn't remember any specifics from your 3-hour-long conversation with plaintiff's counsel from the day before. Got that right?
Yeah, I kind of remind me of the same deposition. It was just the same questions. I was telling my story.
But you told our attorneys that you couldn't remember any specifics?
Yeah, it was the same thing.
No further questions, Your Honor.
Thank you, counsel. Anything further for this witness?
Yes, redirect, Your Honor.
You may.
Ms. Levin, opposing counsel asked you a few questions about who had 3 drinks that night. Did you or Miss Marks have 3 drinks that evening?
I had 3 drinks, but Jessica had a lot more.
Which drinks did she have?
She had like almost a bottle of wine, I think 3 White Claws, and then a beer, and then whatever drink was in that cup.
An opposing counsel also questioned you about your recollection of the events of March 24th. How well do you remember that night?
I keep replaying that same night over and over again in my head, just seeing what I would have done differently. I remember that night very well.
Thank you, Ms. Levin. No further questions at this time. And Your Honor, before the plaintiff rests, permission to also read a portion of Stevie Redger's deposition onto the record?
Is there any recross for this witness?
No recross, Your Honor.
So you may be excused, the witness, and then you may read your rebuttal designations onto the record.
Ms. Becker, could you go ahead and put up Stevie Redger's deposition? What makes you say that Jessica wasn't perfectly sober? She was really loud and she wasn't making a lot of sense. And with that, Your Honor, the plaintiff rests.
Objection, Your Honor. This violates the rule of completeness. The lines on the page below indicate that she was singing lyrics from a song.
Your Honor, may I respond to that?
Sure.
Your Honor, opposing counsel is free to read out those lines themselves, but their objection goes to the weight, not the admissibility of this evidence. This witness, Stevie Redger, testified that Miss Marks wasn't making a lot of sense in his deposition. Your Honor, that does not violate the rule of completeness. That is a thorough evaluation of what Miss Marks was actually doing that night.
Very well, Your Honor. May we read those lines that indicate that this is out of context?
Yes, I think that's the best way to deal with this. If it's a rule of witness issue, I'm going to allow the testimony onto record, but I'm going to allow defense counsel to designate any additional lines they feel is necessary to provide that context.
Mr. Gowda, do you have those lines up? He's screen sharing them now.
That's fine.
There we go. Now, I won't sing the lines out loud to you because I don't have an impeccable voice, but she was singing, "Before you came into my life, I missed you so bad." Singing lyrics from a line.
Okay. Anything further from counsel on this deposition?
No, Your Honor.
Yes, Your Honor, from the plaintiff counsel, just one further section of this deposition, Your Honor.
Okay.
We can use Ms. Becker, could you put exhibit 26 up for the jury? What makes you say Jessica seemed tipsy? She was laughing, talking loudly, stood up and sang a few times badly. She was kind of obnoxious. And with that, the plaintiff rests.
Okay. Very well. Plaintiff having rested, Counsel for defense, do you have any witnesses you'd like to call?
Yes, Your Honor. The defense calls Miss Sunny Mehta.
Ms. Mehta, you you may proceed with your witness.
Good morning, Miss Mehta. I'd like to talk first about what the plaintiff attorney showed on screen. Stevie Rieger testified that Jessica Marks appeared tipsy. Is tipsy different from obviously intoxicated?
Yes.
Would you cut someone off if they were tipsy?
No. Everybody who goes to a bar is allowed to have more than one drink and be tipsy. I only cut people off when they're obviously intoxicated.
Okay, thank you. Can you tell us your name?
My name is Sunny Mehta.
Were you the owner of Sunny's Rooftop Bar on March 24th, 2019?
I was.
Let's get something out of the way right now. At any point on March 24th, 2019, did you think Jessica Marks was obviously intoxicated?
No, I did not. I didn't see any symptoms of obvious intoxication.
A few moments ago, Morgan Levin testified. Were you listening to her testimony?
I was. It was hard to listen to.
She testified Jessica Marks stumbled down the stairs into you. Did that happen?
No, I didn't.
She testified that you yelled out to a bartender that you needed to cut Miss Marks off. Did that happen?
No, and I wouldn't do that. When I cut somebody off, I go up to them, I tell them they've had enough to drink. I wouldn't shout it across the bar.
As the owner of Sunny's Rooftop Bar, are you familiar with the law as it relates to serving patrons who are obviously intoxicated?
Yes, the law says that if I see someone who's obviously intoxicated, I can't serve them anymore.
Have you received training on how to recognize when a patron is obviously intoxicated?
Yes, I completed the state-mandated responsible beverage service course, and I passed the exam.
Was your certification current on March 24th, 2019?
Yeah, it was completely up to date.
Now, during her opening statement, the plaintiff's attorney told you you ignored the obvious that night. Is that true?
No, I didn't see anything, so I didn't know to stop serving.
Tell the members of the jury some of the things you look for to determine if a customer should be cut off.
Everything they trained us on, if I see bloodshot eyes, watery eyes, slurred speech, if somebody can't really walk well, those are the biggest ones. If somebody's passed out drunk, any symptoms like that.
Did you see any of those signs in Miss Marks at any point?
Again, I didn't. I wish I had, but I didn't see anything.
Now, I want to redirect us one more time to that Stevie Rieger testimony. Ms. Rieger testified that Jessica Marks was being loud. Is there an explanation for that?
It's a loud bar. I mean, if I remember correctly, there was a basketball game on that night. There was definitely music playing.
Objection, Your Honor. Speculation as to why Miss Marks was loud that night.
Okay, can you just repeat what the question was again, defense counsel?
Is there any reason Jessica Marks might have been being loud that night?
Okay, response.
Your Honor, it's Miss Mehta's bar. She was there. She knows the general occurrences of what happens at the bar, whether it's loud, whether there's music playing, whether there are games on. Miss Mehta's just giving her lay and reasonable opinion as to whether there might be any symptoms that might have been displayed that can be explained.
May I respond to that, Your Honor?
Sure.
Your Honor, opposing counsel's question is there any reason Miss Marks might have been being loud? And Your Honor, that requires this witness to testify to Miss Marks's intent behind the volume of her voice that night, whether she was simply drunk or was trying to speak over the music. And because opposing counsel is asking this witness to testify to Miss Marks's state of mind, it's speculative.
Final response, Your Honor.
Sure.
Miss Mehta was at the bar the whole night, serving Jessica drinks. About 10 times came to her table. She'd know how to recognize what was occurring and why it might have been occurring. Now, we're not asking Miss Mehta to give a final conclusion on why specifically, but rather whether there were any possible reasons why she might have been being loud.
Yeah, I don't think we've reached into speculation quite yet, so I'm going to overrule the objection. If it goes further into mindset directly, you can renew and we'll take it up then.
Ms. Meta, when on March 24th were you able to observe Miss Marks?
When she first arrived, I saw her. I saw her throughout the night when I searched her table, and I watched her leave at the end.
Miss Levin, Miss Morgan Levin testified that you were there at the table about 8 to 10 times. Do you remember specifically?
I would say that's about right, maybe about 10 times.
And on those 10 occasions, what physical activities were you able to observe her engage in?
Nothing. I saw her sitting.
In all of those interactions, what did you hear about her speech?
She sounded perfectly fine when she was ordering drinks. I wasn't having complete conversations with her, but when she ordered for herself and she sounded coherent.
What did you observe about her eyes?
They looked fine. They weren't watery, they weren't unfocused, they weren't bloodshot.
What did you observe about her coordination?
She seemed totally fine.
Did you see anything or hear anything that led you to believe she might have been obviously intoxicated?
No, I didn't. I know the symptoms to look for, and I know she wasn't displaying them.
Did you see Miss Marks as she was leaving your bar that night?
I did.
What did you observe about her condition at the time?
She looked fine. She was walking okay. She said something to Frankfurt. She didn't sound slurred. There was nothing that indicated to me that she was drunk.
I want to go back to the testimony of Morgan Levin again. Did you hear her say that Jessica Marks was walking in a straight line as she was leaving, as if she was performing a field sobriety test?
I heard that. I didn't see the sobriety test, but that's consistent with what I saw.
Based on your training you received from the state of California, what does a person's ability to walk in a straight line and touch their nose show you with regard to someone's level of intoxication?
It tells me they're not intoxicated. If somebody's not stumbling or falling or tripping, I guess, they're not symptoms of intoxication.
One final matter I want to ask you about, Miss Meta. That's the Instagram video we've seen of Miss Marks at your bar that night. Did you see that video when it was played earlier today?
I did. I saw it.
Did you observe that video being filmed on the night of March 24th?
No, I wasn't there.
Did you ever see Miss Marks in the same condition we could see in that video?
I didn't.
Now, compared to what appears in the video, I want to ask you about the reality of what you observed that night. Did you ever hear Jessica Marks slurring her words?
No, I didn't.
Did you ever observe her have problems with her coordination?
I didn't.
Did she ever not make sense?
No, she seemed perfectly fine to me. Maybe a little tipsy, but perfectly fine.
Did she ever walk in a manner that was abnormal?
No.
Thank you, Ms. Meta. I have nothing further, Your Honor.
Thank you, counsel. Any cross-examination for this witness?
Yes, Your Honor. Good morning, Miss Meta. Can you see and hear me all right?
I can, yes.
My name is Madeline Levin. I'll be asking you a few questions on behalf of Miss Marks' estate. Let's start by talking about how you recognize when a customer is intoxicated. You're trained to recognize the symptoms of intoxication. True?
Yes.
So you know that when someone has had too much to drink, they might start to slur their words, right?
Yes.
They might start speaking incoherently.
Yes.
Well, let's talk about the symptoms that Jessica Marks was displaying on the night she died. You spoke with Miss Marks around 11, true?
I did, yes. I asked her to make sure that Morgan Levin wasn't driving.
Well, when you spoke to Miss Marks around 11, you thought she seemed perfectly fine.
I did, yeah.
You thought Miss Marks seemed sober.
Yeah, when she was walking out at the end of the night, there were no symptoms to indicate to me that she was drunk.
Around 11, you thought Miss Marks seemed sober.
Yes.
In fact, Miss Meta, You think Miss Marks seemed sober every time you interacted with her that night.
Pretty much, yeah.
Let the record reflect Miss Becker is displaying screenshots of what's already in evidence as Exhibit 10. Miss Mehta, you had a chance to watch the video of Miss Marks in your bar earlier in trial, right?
I saw it. I did.
Do you think Miss Marks seemed drunk in that video?
Objection, Your Honor. This is speculation. Ms. Mehta can't testify to whether Ms. Marks was drunk, only whether she was showing signs of obvious intoxication. Drunk is an objective state, and obvious intoxication is something completely different.
May I respond to that, Your Honor?
You may.
Your Honor, on direct examination, opposing counsel laid foundation for how this witness is trained to recognize the symptoms of intoxication. She can answer this question and tell us whether, in her view, Ms. Marks seemed intoxicated or seemed drunk. Your Honor, the words intoxicated and drunk are synonymous. I wasn't asking this witness whether Ms. Marks seemed obviously intoxicated, but given Ms. Mehta's training, she can tell us whether Ms. Marks seemed drunk.
Response, Your Honor.
Yes.
That's a misextrapolation of the law. Ms. Levin can ask whether Ms. Mehta saw signs of obvious intoxication, but not whether she seemed drunk, because drunk relates to the objective level of intoxication, which is not at issue in this case. Only whether Miss Jessica Marks was displaying signs of obvious intoxication. So I just asked that Ms. Levin at least use a different word to describe the video.
Well, I think merely saying drunk is a conclusion that can be based on rationally based perceptions. It's not like she's saying a specific level or a specific BAC level. So I'm going to allow the testimony and overrule the objection.
Yes, Your Honor.
Ms. Mehta, do you think Ms. Marks seemed drunk in this video?
I would think it was possible that she was intoxicated. I don't know. It's a short video.
It was possible that she was intoxicated. If someone came into your bar acting like Ms. Marks was in this video, you'd be concerned, wouldn't you?
I'd be concerned. I'd have to watch them a little bit more, see how they're acting.
That's a yes to my question. You'd be concerned.
I said yes.
Well, Ms. Mehta, you spoke with Ms. Marks around 11 o'clock, right?
I did, very briefly.
And earlier in trial, you heard from Ms. Levin that this video was recorded around 11 o'clock.
Yeah, I did, but this wasn't how Jessica acted to me.
Ms. Mehta, you're telling us this isn't how Ms. Marks was acting around 11 o'clock, but it's true you spoke to her around the exact same time this video was recorded, didn't you?
I did, and this isn't how Jessica was acting in front of me.
And when she spoke to you, she told you she planned on driving home, didn't she?
Yeah, I nudged over to her to make sure that Morgan wasn't driving, and Jessica said, no, I'm driving. Jessica looked fine to me.
Ms. Becker, we can take Exhibit 10 down now. Let's talk about how you reacted when Ms. Marks told you she planned on driving home. You didn't take her keys, right?
No, she didn't look drunk.
You didn't call her an Uber?
No, again, she didn't look drunk.
You didn't cut her off?
No, because she didn't look drunk.
Ms. Mehta, you keep telling us that Ms. Marks didn't look drunk. You know she got into her car that night, just like she told you she would.
I do.
You told us Ms. Marks didn't seem drunk. You know she crashed, don't you?
I do. I wish there was something for me to see that could have told me that she was drunk, that I had a reason to stop serving her. I didn't see anything. I didn't know.
You told us you didn't see anything that indicated that Miss Marks was intoxicated. You know she crashed just around the corner from your bar.
I do. I do.
Thank you, Miss Mehta. Nothing further.
Hey, counsel. Mr. Climaco, anything further for this witness?
No redirect, Your Honor.
Okay. This witness may be excused. Any further witnesses for the defense?
The defense rests.
Okay, the defense having rested, are counsel ready to move into closing arguments?
Yes, Your Honor, plaintiff is ready to proceed.
Defense, are you
As
ready?
is
to
the
vote?
defense.
Okay, we will move into closing arguments then. A reminder to our jury to switching to speaker view to see the attorney on the screen. And with that, I'll turn it over to you, counsel for the plaintiff, and ask if they have a closing argument they wish to make.
Yes, Your Honor. They ignored the obvious. It's March 24th, 2019. Morgan Levin is taking a video of her friend. Both girls have been drinking. Both girls are slurring their words, but one of those girls turns to the owner of the bar and says, "I'm going to drive myself home." Around 11, we know Jessica Marks was obviously intoxicated. We know she told the bar she was planning to drive home, and we know that the bar did absolutely nothing. Members of the jury, in a few moments, this case will be in your hands. You'll have to determine, first, whether Miss Marks was a minor. Second, whether she was served alcohol while obviously intoxicated. And third, whether that contributed to her death. You learned it's undisputed that Miss Marks was a minor. Both sides agree she was just 19 years old. Miss Mehta served her anyway. Was Miss Marks obviously intoxicated? The question isn't whether Miss Marks was blackout drunk, just whether a reasonable person could determine she'd had too much to drink. And members of the jury, you didn't just hear that Miss Marks was intoxicated, you got to see it for yourselves. Members of the jury, in this video, Miss Marks displays all of the symptoms of intoxication Miss Levin told you she did. She's confused. She's incoherent. She's slurring her words. Members of the jury, this video is direct corroboration of Morgan Levin's testimony. You got to see Miss Marks's behavior for yourselves. Now, opposing counsel, they might try to tell you that Miss Marks was just pretending to be intoxicated in this video, that her Instagram account only shows one side of the story, but it's not reality. Members of the jury, we know how much alcohol Miss Marks had that night. We know she had wine, beer, seltzers, shots. We know how that alcohol affected her. We know for a fact that Miss Marks's BAC was 1.6 when she died. So members of the jury, what's more likely? That Miss Marks was pretending for the video? Or that she was as drunk as the numbers tell us she was? Members of the jury, the answer to that question is simple. Miss Marks was intoxicated. It was clear to everyone around her. We've met our burden because we know it was clear to Sunny Mehta how intoxicated Miss Marks was. You see, she took the stand today. She tried to tell you Miss Marks didn't exhibit any signs of intoxication, but on the night in question, she watched Miss Marks trip down the stairs. She said, "We might need to cut this one off." Members of the jury, she tried to tell you she never said that. But remember that Miss Mehta's on trial today. She had every reason in the world to deny that she never said that statement. The fact of the matter is, Miss Mehta admitted that Miss Marks had had too much to drink and she didn't do anything about it. So now, you have to ask yourselves, did the defense meet their burden? You see, before trial, they took on a burden to prove to you that Jessica Marks, a minor, caused her own death. When they get up here in a few moments and they try to prove that to you, I want you to remember one key fact. 1,000 feet. That's how far Jessica Marks made it, 1,000 feet. So when the defense tries to tell you Miss Marks never should have gotten in her car, remember that distance. Remember that Miss Marks didn't have the capacity to make a decision in the first place because the defendant served her and then overserved her and then ignored the obvious. Members of the jury, when the defendant allowed a minor into her bar, when she allowed that minor to get drunk, when she overserved that minor to the point at which Miss Marks was stumbling down the stairs right in front of her, the responsibility to protect that young girl's life, it fell on her. And she failed. She had every opportunity to cut Miss Marks off, to take her keys, to call her a cab or an Uber, to ask anyone else in the bar if they could drive her home, to cut her off. She chose not to. Miss Marks deserved better than that. The law demands better than that. Find them liable.
Thank you,
May I
Counsel.
proceed, Your Honor?
Yes, defense.
Yes, Your Honor. May it please the court, opposing counsel, and members of the jury. There was nothing to see, so there was nothing to stop. But from start to finish, Miss Levin keeps telling you that Sunny Mehta ignored the obvious. Members of the jury, that's not what the evidence proved today. Remember Sunny Mehta's testimony. She had the opportunity to observe Jessica Marks when she arrived, when she took her orders, when she delivered the drinks, and when Jessica Marks left. She was consistent with her testimony that on none of those occasions did Sunny Mehta see any signs of obvious intoxication. And Miss Mehta is trained to see those signs. What she observed about Jessica Marks as she sat at the table gave no indication she was obviously intoxicated. No indication that she had lost control of her faculties. And when Miss Mehta heard Jessica Marks speak, she didn't slur her words. Let's talk about the video you saw. Opposing counsel said it was, quote, direct corroboration of Morgan Levin's testimony. You can't even trust either of them. First things first, remember that Sunny Mehta did not observe Miss Marks make the video. What you actually hearing? It was a little quirky, sure, but it was a production, an act for Miss Marks's Instagram followers. She handed her phone to Morgan Levin and said, I want you to film a video for Instagram. We know, like anyone else does, that Instagram doesn't reflect reality. It wasn't reality when Jessica posted a photograph of 2 empty wine bottles, when the truth was that she and Morgan only had a half bottle before they left the Airbnb that night. And it wasn't reality when Jessica Marks exaggerated her intoxication in the video. But it does make sense. If Miss Marks was exaggerating her condition for Instagram, that explains why Miss Mehta didn't see her acting that way. Because she wasn't. Even if you evaluate Miss Marks in the video, think about what you heard. Miss Marks was speaking complete sentences. You heard her pronounce her words properly. They weren't garbled or mumbled or incoherent. She told you the bar was like a Philly bar, except more expensive. It was $10 for a seltzer, and everyone in Hollywood wants to be an actress or a model. Did you have any trouble understanding any of that when she said it? No. It matches what Sunny Mehta told you about how she sounded when she took Miss Marks's orders. She wasn't slurring her words. She didn't sound drunk. Miss Madeline Levin made a lot of bold claims that Jessica Marks drank several drinks, that she was obviously intoxicated. But let's remember the only things those claims rely on: an untrustworthy best friend, and that untrustworthy best friend's recorded video. The one hard fact, maybe, Miss Levin kept telling you that it was 0.16 at the time of her death, her blood alcohol content. The law doesn't hold Sonny's bar liable just because Miss Marks was intoxicated. Miss Levin keeps telling you that Jessica Marks informed Miss Meta that she was driving home, but if she wasn't obviously intoxicated, it doesn't matter. The law requires there to have been outward signs of obvious intoxication when Miss Marks was served. And sure, hindsight is always 20/20, but what we know now is not the reality of what Sonny Meta knew then. And you must not decide this case on what we know now, but instead on what Sonny Meta observed then, in reality, and not Instagram. So the only other time Sonny Meta observed Jessica when she was leaving that night. She told you she observed her walking without a problem. Is that right? How can you know? Well, you can know because that's what Morgan Levin told you. Remember that as Morgan Levin testified they were leaving, Jessica Marks said she was fine to drive, but what else? Jessica Marks performed her own field sobriety test. She started walking in a straight line, and she touched her nose with her finger. Members of the jury, that's what is observable by Sonny Meta. Walking in a straight line does not show loss of control or obvious intoxication. Touching your nose with your finger shows hand-eye coordination. Now we know that Jessica Marks had a BAC of 0.15. You can't decide this case based on what we know now about the content of her blood, because that's not what Sonny Meta knew then. What Sonny Meta knew then was that Jessica Marks did not appear obviously intoxicated as she sat at her table. Now, Morgan Levin did tell you that Jessica Marks stumbled down the steps and into Sonny Meta. Sonny Meta denied that this occurred, and she denied that she said they needed to cut her off. She did say she hoped one of them wasn't driving, but she said that to Jessica Marks about Morgan Levin. That's because it was Morgan Levin who was showing signs of obvious intoxication that night. Morgan Levin denies that. But remember, you also received evidence from another customer at the bar that night, Stevie Rieger. Stevie Rieger doesn't have a dog in this fight. She's just a witness from the bar. And she testified in her deposition that Morgan Levin was the one who was clearly drunk and wobbling like a boxer, not Jessica Marks. Not only that, but Jessica Marks was Morgan Levin's best friend. The jury, Morgan Levin was here today to do whatever she could, help Jessica Marks' mother win this lawsuit. That's why she was here, to try to convince you to believe that Instagram was reality. What did she tell the cops? She told the cops that Jessica Marks just had 3 drinks that night. She didn't change her story until a 3-hour meeting with the plaintiff's attorneys. Members of the jury, no parent should ever have to experience the loss of a child. As tragic as this case is, the judge will soon tell you that you can't decide this case based on sympathy or an emotion. You must decide this case based on the law. So don't ignore the obvious bias and the obvious signs that she wasn't intoxicated. Find the bar not liable. Thank you.
Thank you, counsel. Any rebuttal?
Yes, Your Honor.
Okay.
Nothing to see? Members of the jury, we know that when Jessica Marks was in the bar that night, she was just minutes away from crashing her car just 1,000 feet from the place she was served. Is it likely that Miss Meta didn't see anything? didn't see any signs of intoxication. Members of the jury, you quite literally got to see how Miss Marks was acting that night. You got to see her drop a can of alcohol. You got to see her put on her sunglasses in the middle of the night. Loss of judgment, loss of balance. Members of the jury, those are all symptoms of obvious intoxication. There was everything to see. Find Sonny's rooftop bar liable because they ignored the obvious. Thank you.
Thank you, counsel. With that, the case will be submitted to jury. I am going to wrap up my ballot, as will my fellow jurors too. When they do that, I just ask that they shoot me a message so we can keep track to figure out whenever